Mark's joining me now. California Congressman Mark Takano, who was very patient with us as we waited for the president to speak. Congressman, thanks so much for being here. Just your initial reaction to this very quick move by the president to try and find another pathway to deliver at least some level of student loan relief. Do you think it's going to be enough and it's going to come quickly enough for the people who are looking for it?
Well, certainly I was aligned with the president in his initial targeted loan forgiveness efforts through his executive actions. The court has put its substitution, it substituted its policy preferences rather than interpret the law. I believe the HEROES Act clearly gave the president authority to modify loans. They decided that modify did not mean what modify meant. The president clearly had the authority to do this under the statute. The court simply just decided that they were going in an unelected way serve as its own legislature for the United States of America and become essentially substitute the court's ruling for the Congress. They became themselves the Congress and the president.
And I assume that when you're talking about this issue having to do with student loans, you're also talking about some of the other decisions that came out this week. Of course, we had the issue related to the LGBTQ rights issue and freedom of speech with the website design for a same-sex couple. And then, of course, the affirmative action ruling as well. Just in general, and I know you've put out a number of statements in this regard, how concerned are you about the direction of this conservative court? And does Congress have any sort of role to try and rein in what you and your fellow progressive colleagues feel is a problem?
Well, I'm very concerned because these three cases together have some things in common. And one of the things that jumps out at me was the aggressive way in which this court granted standing for the plaintiffs. Standing is a legal term, and what restrains the court from just becoming its own legislature to deciding questions before it willy-nilly is this idea of standing. There has to be a real something really at stake for the plaintiff. They really have to be harmed. So in the case of student loans, several states' attorney generals brought the cases forward against President Biden's student loan relief. Hard for them to prove that their states or that they were being harmed. So it came down to a loan processor named Mohila, which is not even a state, to say, well, if President Biden relieves all these students from these onerous loan payments, they're going to make less profit from processing those loans. They turned that into standing for the several states. Something similar happened with affirmative action. A made-up group, Students for Fair Admissions, not even a real student. Unlike the Bakke case in affirmative action, there was not a particular student that was harmed and was granted admission to either Harvard or the University of North Carolina. And in 303, the 303 creative, very hypothetical issue over the digital, creative artist. So look, the court reached out to bring these cases to them. To my mind, very big overreach of power. The way we check that is we need to change the composition of the court. So,
and when you say change the composition of the court, does that mean that you believe that President Biden just adds to the current roster of 9 justices? Is that the most immediate solution?
Well, Congress has a role in this. Congress, at various times throughout our history, the court has been as large as 15, as small as 7. It's not been 9 for all the time in our republic. Congress has adjusted the size of the Supreme Court several times. And in fact, when the New Deal legislation by President Roosevelt was threatened by an aggressive activist conservative court, he attempted to pass legislation to enlarge the court. It was called a stitch in time, or switch in time saves 9. It was an effort in the 1930s to expand the court. So it's been contemplated before. It has been done before. Congress, by simple majorities in each house, can adjust the size of the court along with Of course, the president signed
Do you
the
think
bill.
that that's realistic, given the current makeup of the Congress, that you could, even with a simple majority, get to a position where Congress would give the president the authority to add more justices?
No, the current makeup, of course, we have a House controlled by extreme Republicans. They would never contemplate it. But the court needs to understand another form of restraint on the court, besides standing, is the knowledge that if they go too far, the political branches have the option of altering the size of the court. And that's a legitimate check. It's contained in the Constitution. It's very constitutional. And if the court continues to overreach in the way that it has done in these most recent three cases, that is going to become a political issue in the November of 2024.
So it sounds the direction you're heading in here is that this should be a campaign issue, that you should go to voters and say, you know, the solution here to fix, if you're unhappy with the direction of the Supreme Court, is to vote more Democrats in office. Do you believe that this is going to be something Democrats like you are going to go across the country and make that case in the 2024 election? How big do you think the recent rulings of this Supreme Court will play in the 2024 election?
I think they are huge rulings. I think the idea that that you're not going to consider, race at all, not as the only factor, but as one of many factors in college admissions, whether it's denying LGBTQ people the ability to be treated fairly at a business, that a business's beliefs can trump their obligation to serve everybody that comes through their doors. The idea that we would go back to the days of the Green Book that African Americans had to carry around with them because they were unsure whether a hotel or a motel would serve them. That's the beginning of what's happening in the 303 creative case. Whether it's the abortion rulings of this court, these are extreme, out of touch rulings by this court, and they've done so in an aggressive manner. And at least these three cases, they've gone out of their way to bring plaintiffs into the court so that they could make these decisions. And they're acting like a legislative body than a court that is restrained, that really waits for true adversaries to appear before them. They're seeking out people who match their policy preferences to bring cases into their court.
Okay, Congressman Takano, I appreciate you taking some time out during your legislative recess. I know you're very busy in your district right now, and I appreciate you rolling with the punches here on an unpredictable afternoon on this program. Thank you so much for being here. We appreciate it.
My pleasure. Appreciate it being on.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.